or standard of proof is minimum. See the case of Oguma Associated Companies, Nigeria Limited versus IBWA Limited. The citations are supplied. See also SPDC, Nigeria Limited versus Damkwe and others, Uwahiari and another versus Onyemaizu and another, and Eroku and another versus Oroku. The citations are supplied in the ruling. In the circumstances of the law are stated, it is my considered view that the claimant's application per se is not grantable. I so find. This matter shall accordingly proceed to trial in accordance with the minimal evidence rule. I so hold. Ruling is read and delivered. Ruling is read and delivered in open court.
As the court please.
Via Zoom.
As the court please.
Here. Who's appearing for the claimant in this ruling? No appearance.
As court please.
Registrar, give me a date for hearing. Is the registrar of the court there? Registrar, give me a date for hearing of this matter. Is the registrar there? The date for hearing to the parties by the registry of this court. Number 2 on the course list. Case number 2 on the course list is Edwin, NICN Asaba 19-2021. NICN Asaba and Life Assurance PLC. Appearances in that.
Recording in progress.
NICN, Asapin, Aterogo, and Alliance and General Life Assurance PLC. Appearances. Appearances. Appearances in number 2. NICN Asaba 19/2021. Edwin Aterogo versus appearance of counsel. Wow. So can we proceed now? Can we proceed now with number 2 on the course list?
Recording in progress.
Yeah, hello. Hello.
Good morning, Your Lordship. I'm trying to log on, but I'm connected, but the first time network actually logged me out. I'm connected again, but I can't. Good morning, Your Lordship.
Good morning. Are you in number 2?
Good morning.
NICN Asaba 19, 2021. Who is in that matter?
My Lord, is it Anthony Kaiser versus Delta State University Hospital?
That is not the case where we are now. We are with Edwin Aterogo versus Alliance and General Assurance PLC. That's the case we are doing now.
I'm not in that. Okay, my Lord. I'm very sorry, my Lord. I'm not in that.
You wait for your own. You wait for your own. Edwin Aterogo, NICN Asaba 19, 2021. Edwin Aterogo versus Alliance and General Life Assurance PLC. Who is in this matter? Who is in this matter? NICN Asaba 19/2021. Edwin Aterogo versus Alliance and General Life Assurance PLC. Registrar, what is the position of this suit?
My Lord, I just called to the claimant counsel.
Yes.
My Lord, they said they want to log in again, that is having issue with the internet connection, my Lord. Then the defendant offered any process in this matter, my Lord. Only the
That is why the claimant should tell us what should happen now.
yes, my Lord.
I think it's for mention. Is it for mention?
The one who went to they gave out against us. We will fight. We will fight against the majority. People don't fight, but they give them against us.
So, Registrar, can we take a date for further mention?
Yes, my Lord.
Okay. But has the defendant been served the originating processes?
Yes, my Lord. The originating processes was served on the defendants, my Lord.
Give me a date for further mention.
Yes, my Lord. 2022, my Lord.
26 what?
26th of January 2022.
So this matter is adjourned to the 22nd. Hearing notices be issued and served on counsel to claimant and on the defendant or counsel if represented. Proof of service of same to be filed in the case file before the next adjourned date.
As the court pleases.
My lord.
Thank you. Is the registrar there?
I'm here, my lord.
Registrar. The number one matter that I delivered the ruling in Boniface or Akwe versus Microfinance.
Yes, my lord.
You will pick a hearing date. What is the date for hearing?
Yes, my lord. The date for hearing is 1st of February 2022, my lord.
So for Boniface and Orakwe versus Ozondo Microfinance Bank Limited, the matter is adjourned to the 1st of February 2022 for hearing.
As the court pleases.
As the court pleases.
We are at number 3 now. Dr. Amechi Nwachukwu versus Chukwuemeka Odimogu Ojukwu University Teaching Hospital and another. NICN OCA 11/2020. Appearances in this one. NICN OCA 11/2020. Dr. Amechi Nwachukwu versus Chukwuemeka Odimogu Ojukwu University Teaching Hospital and another. Appearances of counsel. Appearances of counsel. Somebody was there earlier talking about this matter. Told him to wait. We'll finish the other case before we come to this one. I can't hear him again. NICN OCA 11/2020. Dr. Amechi Nwachukwu versus Chukwuemeka Odimogu Ojukwu University Teaching Hospital and another. Who is in this matter? Okay. Registrar, what is the position of this suit?
My lord, I'm trying to the claimant counsel, but he's not picking his phone, my lord. The defendant counsel, also, I called him now. His number is, my lord, the position of this suit, both parties, they have filed their report of settlement, their terms of settlement.
Okay, they have filed their terms of settlement.
Yes, my lord. The matter was slated for today for them to come and adopt their terms of settlement, my lord.
Well, and I have not had the opportunity of looking at the terms of settlement. But they are duly filed in court and signed by both of them.
Yes, my lord.
Okay.
Don't help you now. Don't be sick or tired. Huh?
So this is my judgment. The terms of settlement filed by the claimant and defendants are deemed adopted in view of their absence in court. The said terms adopted are accordingly entered as the judgment of this court in this suit. I so order.
As the court pleases.
Next one is on number 4 is Anthony Kaiser.
Yeah, hello. 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 Yes, I mean, that matter, Dr. Mechi went to go. against Chukwemeka Ojukwu University Teaching Hospital and another. We are in receipt of notice of withdrawal filed by the plaintiff, and I have the consent of my clients, the defendants, to agree that the matter be withdrawn. The management had before now given the consent for that to be done. May the court enter judgment in view and in terms of the contents of the notice of withdrawal.
We have done that already. We have done that already. We have done that already. Next case is Anthony Kaiser and Delta State University Teaching Hospital, Ogara, and 4 others. NICN Asaba 11/2020. Appearances, please. Appearances is in Anthony Kaiser versus Delta State University Teaching Hospital, Ogara, and 4 others.
My lord.
Yes.
My lord.
Yes.
Well, we are for the defendant. We are for the defendant.
Is that how you announce your appearance?
No, my lord, very sorry, my lord. With utmost respect, my lord. Respectfully,
is that
my
how
lord,
you announce your appearance?
M. Akbodinho. My apology, my lord. Apology, my lord. With utmost respect to court, my lord. I am M as in initial for Monday. M initial for Monday. Akbodinho, my lord. Akbodinho is spelled AKPODINYO. AKPODINYO, my lord. I'm holding the brief of BN Ebluma, my lord. I'm holding the brief of Victor N. Eluma, my lord. He has been trying to join the meeting, but has been having a network problem due to his bad phone. So he called me, my lord, to assist him to log on. My lord, our whole appearance is for the defendant, my lord. My lord?
Yes.
My lord?
Yes.
I said, M, initial for Monday, M, as in Monday,
yes.
my lord. Akbodinho is
yes,
AKP. Yeah, my lord, I'm holding the brief of VN, as in Victor, N, as in Nigeria, Eluma. Eluma is spelled
wait, let me hear your spelling. I mean, the spelling of it. Listen to me. Let me hear your name, the spelling of your name correctly. AKPOD.
Okay. I-D-I as in dog, D-I-N as in Nigeria, Y-O. AKPODINYO.
Yes.
My lord, I am holding the brief of Victor, VN, as in N initial, B initial, N initial. BN Eluma.
For the defendant?
Oh, yeah, for defender, my lord. Yes, my lord. Yes, my lord.
Okay. Who is appearing for the claimant?
My lord, it's a cancer. It's a cancer. Maybe he's trying to log on. Maybe the network has been very bad. But my lord, it's for further mention. Yes, my lord. It's for further mention, my lord. We have filed our statement of defense, but we came in through application for extension of time, my lord, to regularize our process.
How come is
You want to become if you want to become Supreme Court judge.
Defendant's counsel, you can proceed with your application.
Yeah, my lord, let me first apologize for this bad network, my lord. My lord, my learned counsel, who is actually with the case file, called me, and I do not have the case file. With leave of court, if the court will be magnanimous enough, I'll be craving the indulgence of court to enable us to move in terms of our motion paper, my lord.
It's muted, okay. You go back and now you're mute.
So is it for the first defendant or is it for all the defendants?
All the defendants, my lord, all the defendants, my lord.
Yeah, okay. Okay, now don't go carry on, man.
Well, but your application is in respect of the first defendant only, not all defendants.
Yeah, yes, my lord. But most often, because it is the Delta State University Hospital that is actually sued, and that's what we are appearing for, my lord. But in any case, my lord, we always been the one defending our matters, because it is a statutory body created by the law of Delta State, my lord.
Which one is that you're talking about?
If you go run for that,
My lord, it's Kaiser Anthony, my lord, versus Delta State University Hospital and others. Apart from the Commissioner for Health and the Attorney General, my lord, we are appealing for all other defendants.
So, how you mean now? But that you have a ground from, also know the runner.
I can afford to sit down, but I cannot do that. Just so that even they carry the paper follow the road. The network is so bad that we log you out, we log you in. And the fight with my learned senior, because he was actually doing all he can to log on, but he couldn't.
Please, the court is
He
sitting.
has to call me to log on so that.
Please, the court is sitting.
The person should know that he is before a court. That person talking.
As the court pleases.
If you want to say anything in private, mute your phone. Mute your phone.
As the court pleases.
I can't stop you from talking, but if you want to talk, mute your phone.
As the court pleases.
As the court pleases, my lord. I must.
Quote. The application of the defendant seeking dated 10th August 2020, filed on 12 August 2020, seeking extension of time to file the adjourned statement of defense is granted as read.
As the court pleases.
The said processes are deemed as properly filed and served. I so order.
As the court pleases.
As the court please. We are most grateful.
Yes.
We are most grateful.
Yes.
My Lord,
Yes,
the
what
date, my
next?
Lord.
For hearing?
My Lord will be guided by the court, my Lord. We should be guided by the court, my
Okay.
Lord.
Yes, registrar, what date for hearing?
1st of February 2022, my lord.
It's convenient, my Lord. My Lord is convenient, my Lord.
1st of February?
Yes, my Lord.
Yes, my lord.
It's convenient, my Lord.
Okay.
No, February.
So this matter is adjourned to the 1st day of February 2022 for hearing.
As the court pleases.
The hearing notice be issued and served on the claimant's counsel, proof of service of same to be filed in the case file before the next adjourned date.
As the court pleases.
Yes. The next case on the list is NICN Asaba 50, 2020, Mrs. Vivian Zamani and another versus Warri Refining and Petrochemicals Company Limited and 2 others. Appearances.
May it please my noble Lord, if I'm being
Yes.
heard, my Lord, I'm Chief Robinson Ario. Chief Robinson Ario. My very humble appearance, my Lord, is for the claimants. Chief Robinson Ario very humbly appears for the claimants, my Lord. We most oblige.
Yes.
Respectfully, my Lord.
Yes.
My name is D.U. My initial D.U. My surname is Ezumezu. My Lord, Ezumezu is spelled as E-Z-U-M-E-Z-U. I most humbly appear for the first defendant.
You're for the first defendant only.
My Lord, for the first defendants only.
Okay. So who is appearing for second and third?
They have never been represented, my Lord, even though they've been served the processes.
Oh. So what is the business of today?
My Lord, the matter is listed for report of settlement today. And my Lord, we regret to inform court that settlement has broken down. The matter is listed for settlement, report of settlement today. And we regret to inform this honorable court that settlement has broken down as a result of the lack of cooperation of some of the defendants. Lack of cooperation of some of the defendants. We are therefore, my Lord, ready to go on with this matter. We are therefore, my Lord, ready to go on with this matter and do have an application before court. And do have an application before court.
My Lord, if I may come in, sir, I may want to correct the impression made by Claimant's Counsel that settlement broke down as a result of the uncooperation by the some of the defendants. That is not the position, my lord. I think settlement broke down as a result of the claimants who were not willing to cooperate, sir. Because we forwarded terms of settlement. I, as counsel, I signed terms of settlement on behalf of the first defendant. And they told me they were leaving my office and taking it to my clients, which is a director in the first defendant's company, to sign. But they never did. I have a photocopy of the terms of settlement duly signed by everybody except my clients. They refused to take the document there. So I just want to correct that impression. But if they feel if they feel the settlement has broken down, then we are willing to go on, sir.
My lord.
I just want to correct that impression.
My lord, I don't think my learned friend is in a position to correct an impression in a matter in which he represents only one of the defendants and does not represent the other two defendants. Secondly, in a matter in which he has admitted that we did leave our office and brought a draft of terms to his office. In other words, he was just seated in his office. He didn't know anything that went on. It was we who took the terms of settlement to his office. And it was we who are now informing court that the conduct of some of the defendants made settlement impossible. And I think what learned counsel should have done would have been to get in touch to be properly informed of what happened. Because if we are not mad people, we drove a process in which you are not fully involved, and at a point, we told you that the characters involved are not cooperating. Then you shouldn't come to court to tell court what you are not seized of, you're not personally experienced of. My lord, I am saying this because I personally drove this process.
I drafted the terms of settlement, not you, Mr. Rio. I drafted the terms of settlement. Don't tell me I'm not involved.
You have said that we brought it to your office.
After you signed, you brought it to my office.
The point I'm making is that I drove the process. You sat down in your
office. What process did you drive?
Take executing the terms of settlement.
Please, if you want to mention any defendant, be specific about the defendant, because I am a defendant. That was why I drew your attention.
You were being presumptuous. That is what you should have said in the first place that I should mention. But you presumptuously went ahead to say that it's a lie. You know, if you had asked for further particulars, you would have been given further particulars, and that's the point I'm making. Even if you had...
Mr. Rio, we both spoke on phone. I asked you, I said, take the document to my client to sign. You refused.
I'm not talking about what we spoke on phone. I'm talking about your representation.
Okay, then what are you talking about?
Your representation in court this morning. You have said in court that it is the claimant. When you did not participate in the execution process, the activity of execution of the draft terms of settlement, how would you be in a position to know that?
When we spoke on phone, I said take a document to a particular person to sign. You refused. Is that not?
Have you gotten a feedback from that? How did you come to the conclusion that you just disclosed now? How did you come to that conclusion?
Please, like in court, you said the settlement has broken down, so we can proceed.
So,
I just want to correct the impression.
We have an application before court. The application is dated the 8th day of November 2021 and filed same day. My lord, we're actually seeking, in view of the collapse of the settlement process, we are seeking to reply to the first defendant statement of defense. And then the supreme witnesses have their statements brought in. That is the only essence of this application, my lord.
My lord, sir. My lord. My lord, if I may speak, sir.
When you were quarreling, did I permit you to quarrel?
We are sorry,
When
sir.
you were quarreling.
I am sorry, my
It's
lord.
not based on the court directive.
I am sorry, my
I don't
lord.
know why mature people like you be behaving like that. Did I
You are very sorry,
permit you to quarrel?
I am very sorry, my lord.
See, both of you, let me tell you people something. Both of you are more familiar with the adversarial system of litigation. When you are representing your client, the idea is to slug it out, to fight it to finish. And a lot of counsel would want this kind of conflicts to pervert so that they will reap from it, so that there will be siphoning money from the litigants they are representing. They don't want settlement. If the matter is settled quickly, they wouldn't have any source of siphoning money from their clients. Pay for this, pay for transport, pay for accommodation, pay for that, pay for that. And then the substantive fee is still there. If both of you are not rooted in negotiation, in which case you give and take, you give a little, you take a little. You have to yield grounds. That is what negotiation is about. You have to yield grounds. You have to give up some claims. You have to give up some issues so that you give and take. And the give and take is for both sides. So when you stick to your position without moving or shifting, how can you get a settlement? So both of you don't know anything about settlement. It has to do with negotiation. And you have to train yourself in negotiation skills. You have to train yourself diligently in negotiation skills. That is when you settle. It is only when you settle that you begin to draw up terms of settlement. You don't just write terms and take it to anybody. You talk, you negotiate. It's when both of you have reached a consensus that you sign settlement. When you have not discussed and reached consensus, what are you pushing paper up and down for? That is what they call negotiation.
Madam, we really appreciate your advice this morning.
People don't know it.
Yeah, we really appreciate. How can you
get a settlement? How can you get a... Wait, I'm talking. Don't interrupt me.
I'm sorry.
When both of you were quarreling, did I interrupt you?
No, my lord. I thought my lord had finished.
When both of you were quarreling, did I interrupt you? Now that I'm talking, now you are prognosing.
I'm sorry.
That is not settlement. That is not settlement. Settlement, you have to yield grounds on both sides. You don't stick to your grounds. Because of the adversarial nature of litigation that both of you are rooted in. In this court, in labor matters, both sides sit at a table. That is why we have ADR centers in all over the country. We have ADR centers in this court because in labor matters, there has to be settlement at a table. You sit on the other side, the other group sit on the other side, and you negotiate. You talk to each other. When it is heated up, you take a break. You go and re-strategize, and then you come back for settlement. That is what happens at the ADR centers. So when parties opt for themselves to settle, that is the same procedure they should follow. If you can't reach a settlement today, go back and think. Then you come back with another strategy with a view to settlement. What the people are doing is not settlement. You don't know settlement. You don't know negotiation. That is what has come out clearly. Both of you don't know what it means to negotiate and settle. That is why you are bickering even in court. That is why you are bickering even in court. It's a shame. It's a shame. Yes, Claimants Council, you said you have an application. What is it about?
First of all, let me apologize to my Lord. If I may, I apologize to my Lord, and I do appreciate, as a matter of fact, what my Lord has said. And coincidentally, I'm a mediator. My Lord, I feel embarrassed that I'm finding myself in this kind of position. As a matter of fact, I at all costs ensure that amicable resolutions are attained. In this particular instance, my Lord, I even surrendered. In fact, it was a slavish kind of thing. It came from up down. I absolutely gave up because when we were talking, it was only just one person that was pushing down a position on us. But in order for there to be peace, I still kept quiet until I couldn't keep quiet any longer. I want my Lord to understand that, you see, I appreciate exactly my Lord's. I have my Lord's position on this. My Lord, this was a matter in which they alone took a position and pushed down our throats. And because I was bent at all costs on settling, my client accepted it. I even accepted it and signed. But at the point when arrogance even was now piled on that slavish one by unilateral position, it became so unbearable. But there was never a discussion. Even the discussion that the claimants had with them was a one-sided thing. They never wanted to shift. I don't want to mention particulars, my Lord, because my Lord could be prejudiced. But if I mention particulars, my Lord will understand what we're talking about. Like my Lord said, negotiations about shifting positions. It was just a position. Somebody went to the table with his hand full and came back with his hand full. That was what it was. And it became a slavish kind of thing. My Lord, we are still prepared and positively disposed to a proper negotiation process. Because
let me hear your application. What? Wait, it's okay. What is your application about?
My application is for extension of time within which to file our reply to the first defendant's statement of defense, and then bring in the statements on oath of the subpoenaed witnesses, which have been pleaded before.
Have you served your application on the defendants?
Yes, my Lord.
Okay.
My Lord, sir.
You say you have an application to do what? Let me hear you.
The application is for extension of time. Extension of time within which the the application is for extension of time within which the claimant applicant may file their reply to the first defendant's statement of defense. The application is for extension of time within which the claimant applicants may file their reply to the first defendant's statement of defense time allowed for
Yes.
so doing having expired, and to bring
Yes.
in the statement on oath of supine witnesses so as not to take the defense by surprise, and to bring in the statement on oath of supine witnesses so as not to take the defense by surprise. Because that's the entire essence of the application.
Did you serve it on the defendants?
Yes, my lord.
First Defendants Counsel, let me hear you.
Yes, my lord. Again, my lord, I profusely apologize for the heated arguments before my lord. I do not want to join issues
We are
anymore.
moving on already. That's okay. That's okay. That's okay. No problem. No problem.
I am grateful. I am grateful to my lord.
Yes,
Okay, my lord.
no problem.
We received some processes yesterday. Yesterday at the close of work, my lord, we indeed received the motion claimant counsel just talked about. But my lord, of particular concern, sir, is the prayer for. It said that the processes, the witness statement of oath, the witness statement on oath of ASP Azunuwa Patrick and Dr. Clement are already filed before court, but those processes were not served on us.
Okay.
Those processes were not served on us. Then number two, my lord, motion for extension of time, sir, is not granted as a matter of course. There is nowhere in their prayer where they gave any reason whatsoever why they are bringing this application.
So you are taking the position of the judge now.
My lord, sir, I am drawing it to my lord's attention. My lord, they filed an affidavit before court. It's a process served on me, and I am telling court that they are not stating any reason whatsoever. It's left at the discretion of my lord, but my lord, of particular note is that the statement on oath has not been served on us.
It will be served on you before the next adjourned date.
As the court places.
So this is my ruling. The application of claimant's counsel seeking extension of time to file reply to first defendant's statement of defense is granted as prayed. I so order.
As the court pleases. We are very grateful, my Lord.
The statement on oath of subpoena witnesses be served on the defendants without delay. I so order.
As the court
pleases. We are grateful, my Lord.
Claimant's counsel, you will ensure that those statements are duly issued and served on the defendants.
As the court pleases, we will do that, my Lord.
Yes. Yes, what next?
My Lord, subject to my Lord's direction, it would have been right for hearing, and we do have a weakness if my Lord is opposed to that.
We can proceed for hearing today.
As the court pleases.
We can proceed to hearing today.
As the court pleases. If we may then be guided.
Your statements on oath have not been received by first defendant. You heard him.
Yes,
they
but
have to have all of that.
Yes, this particular witness statement on oath has been received by them.
I will not hear this matter today.
As the court pleases, as the court pleases. If we may be guided then, my Lord, as to a date.
Registrar, give me a date for hearing. Registrar, give me a date for hearing.
My Lord. 1st of February.
1st February. Gentlemen, is that okay by you?
Yes, my Lord.
Very convenient, my Lord.
1st February.
Very convenient,
both of you. First
my Lord, sir, I just want to beg. We are coming from Warri, and there is always sit at home on Monday in the East. We may want to travel on a Tuesday and arrive in Oka, then do the matter the next day. So I don't know if it may be adjusted to a Wednesday so that we can travel on Tuesday rather than travel on Monday. My Lord, that's our only constraint. We don't know how the sit at home, the period it will last.
Well, they relaxed it for the election, so I'm sure they will relax it for subsequent days. I don't know. But I think it's better we play safe too. I agree with you.
As the court pleases, we are grateful, sir.
My Lord, even at that, I do not know if there is anything preventing us from if when my Lord from sitting
Is that date that of sorry?
My Lord, I was saying that in view of the
You
issue of
said
security, I was saying that in view of the issue of security, I do not know if my Lord can sit in Asaba for this matter.
we are sitting in Asaba. If you want it in Asaba,
My Lord, we prefer Asaba if it's convenient for the court.
I don't know whether we have scheduled the. I think we have not scheduled the next year sitting in Asaba yet, but we are about to do that. Have we done that?
Registrar.
The registrar
No, my Lord, we have not.
We have not yet scheduled sitting in Asaba, but it's on our plan. We are sitting in Asaba. You should be rest assured of that.
As the court pleases.
It's a welcome development. We are grateful to court, sir.
Yes. We're even planning to sit in Asaba before the end of this year.
As the court pleases. In that
would be great.
But for this one, it is next year. We are not scheduled next year yet. That is just the problem.
Okay,
my Lord, we are amenable to a date being communicated to us for the overriding interest of security. If by the time my Lord is prepared to settle for Asaba, schedule for Asaba, then we can be accommodated. We will really, really appreciate it, my Lord.
So do we leave it open or what?
Yes,
what are you
my Lord.
suggesting?
What I'm suggesting, my Lord, is that in as much as my Lord has not yet it will and propose it for Asaba, or we leave it open until that schedule has been drawn up, my Lord.
Well, when we fix a date, I think we will communicate it to you.
As the court pleases. As the court pleases.
Okay.
As the court pleases.
So for now, we will leave it open, but definitely either in January or February, we'll be sitting in Asaba.
As the court pleases.
As the court pleases.
So for now, both of you agree that we'll leave it open?
Yes, my Lord.
Yes, my Lord.
Okay. This matter is adjourned to a date to be determined for hearing. Hearing notice be issued and served on counsel to second and third defendants, proof of service of same to be filed in the case file before the next adjourned date.
The court pleases.
The date will be communicated to you.
Very well, my Lord.
Yes.
My Lord, permission to leave the meeting.
You can't leave before me.
No, okay. I thought that there were other lawyers. As
I think, Registrar, is it the last case? Registrar, do we have another case?
Yes, my Lord. That's all for today.
Sorry, that will be all?
That's all for today, my Lord.
Okay. That will be all for today. The court stands adjourned.
As the court pleases.
As the court pleases.
Yes.
Yes, my Lord.